Greetings and welcome to Summary Judgment, condensed from American jurisprudence. We're going to be getting into this presentation shortly here, and I just want to remind everyone to please hit the like on your way in, and we do have the talking chat enabled, I believe, so we should be able to get instant feedback from your comments to make sure that we keep this interactive.
The tribe says, hit the like.
There we go. So it is active, and just to let you all know that this is strictly for the entertainment educational purposes of this YouTube broadcast, not to be used, misconstrued, or abused for anything illegal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. All right, so first of all, the nature and scope in generally. A summary judgment is a procedural device designed to promptly resolve controversies without trial by determining whether genuine issues of material fact exist, material fact being central to the dispute. So, the primary purpose, determine if triable issues of fact require a formal trial. Are they issues of fact that are contested, or is it just of law? Promote search for undisputed material facts for judicial decision making. So if there's any undisputed material facts, then it's just a question of law, not a question of facts. Therefore, it'd be eligible for a summary judgment. It eliminates unnecessary trials to avoid delay and expense, of course, judicial efficiency. Useful for unmasking frivolous claims and ending meritless litigation. So, we all know about the kinds of obstructive lawsuits that can be filed. A summary judgment is one way to address that. And the Federal Rule of Procedure 56 is designed for prompt disposition when no genuine issue exists. So, what you may ask is Federal Rule of Procedure 56. Well, luckily, we get that here ready to go for a quick overview because we can't really proceed with this unless we're familiar with federal rules of procedure, because even the state laws are based on it. So that said, let's look into this a little bit more. Here, let's see here. What happened here? Just a moment. All right, here we go. So the Rule 56, it goes over summary judgment, and this is rule of federal civil procedure. So summary judgment is a procedural tool allowing courts to resolve cases without trial and when there is no genuine dispute of material fact. The standard is no genuine dispute of material fact, plus it's entitled to judgment as only a matter of law. The timing is any time until 30 days after close of discovery. So after 30 days after discovery is closed, it's no longer eligible for a summary judgment. There's evidence requirements, citations to record materials, affidavits, declarations, or other admissible evidence. So there's requirements for the summary judgment. And there's a burden of proof. The movant, the one making a move for a summary judgment, initially bears the burden, but then that burden of proof shifts to the other party, the non-movement, to show genuine dispute. So initially, the movant has the burden to bear with these evidence requirements, but then that burden shifts to the non-movant to show a genuine dispute, again with evidentiary requirements, ideally. So there's motion requirements and timing also under Rule 56. So we have Rule 56A, which is the motion for summary judgment. A party may move for summary judgment identifying each claim or defense, or the part of each claim or defense on which the summary judgment is sought. So the court grants the summary judgment if there is no dispute of material fact. Once this has been identified, the movant must be entitled to judgment as a matter of law. And the courts must state reasons for granting or denying. Now, this seems straightforward here, but remember, their reasons could just be standing presumptions and such. So it's still, there's a bit of a back and forth really to get those reasons on the record. So 56B goes over the time to file a motion. So unless a different time is set by local rule or other court orders otherwise, so we'll find those local rules really affect these times to file the motion. A party may file a motion for summary judgment at any time, but until 30 days after the close of all discovery. Keyword, all discovery. The standard deadline is 30 days after discovery closes, but local rules may establish different timing. Court may order otherwise in specific cases. So the court order is the one that's really going to make or break what happens here in those cases with the timing. So a court order in most cases would be able to overrule these other, standard deadlines. Now, Rule 56C. Number one, we get the supporting factual position. So the requirements for supporting facts. There's one method. Method one, cite record materials. You must cite particular parts of materials that are already in the record. Let's look at some of those acceptable materials. We got depositions, documents, electronically stored information. Key one here is affidavits and declarations, stipulations, admissions, interrogatory answers, all these pretrial things, and other materials. So there's another method. Method two is show materials don't establish dispute. Here we're getting to that logical, it's almost like the modus tollens, right? Show that side materials don't establish absence or presence of genuine dispute, or that adverse party cannot produce admissible evidence. And let's move along here to Rule 56C2. Objection to evidence. Objection that a fact is not supported by admissible evidence. So it's an inadmissible form is one objection. The material cannot be presented in admissible form. And then there's evidentiary issues. It fails evidentiary requirements. So perhaps it's part privilege or for whatever other reason can't be considered as evidence. And there's also the inadmissible form. Maybe something that can't be verified. Then there's the common objection grounds. There's hearsay without applicable exception. There's the evidence outside the time frame of discovery. Of course, we've read that one. Improper expert testimony qualifications, which could be a difficult one, but it is an objection for common grounds here. And then there's the privileged communications, ones that can't be admitted as evidence because the court can't really be privy to those communications in an admissible form. And finally, objections must be specific and identify the evidentiary basis for inadmissibility. All right, let's move on. We're almost done here with Rule 56, but this is the foundation for what a lot of the other rules are built on. So by having this well understood, it makes the rest of the building blocks fall into place nicely. So on Rule 56C3, the materials not cited, so the court's consideration of evidence. What's required, the courts must consider the cited materials. What's optional, or court may consider other materials in the record. So it can be admitted, but whether it will be considered is under this Rule 56C3. So, practical implications. Uncited materials carry less weight. The court may search the record independently, and proper citation strengthens the arguments. And a comprehensive record is beneficial. So, again, having citations and having the record cited is a lot different than having the court search independently. So uncited materials carry less weight of evidence. And remember, the evidence is weighed. So this is an important consideration here regarding the materials when they cannot be cited. While courts may consider uncited materials, parties should always cite specific evidence to support their arguments. So remember, when they may consider is a lot different than they must. So cited materials, the courts must consider. And if they're not cited, the courts may consider. Now we're on to Rule 56C4, affidavits or declarations. So the requirements for affidavits or declarations are personal knowledge, made on personal knowledge of facts, not I saw him do this or I heard her say that. There's admissible facts, contain admissible evidence if testified, and competency, show competency to testify. So again, these are all elements that need to be present. The key considerations: affidavits and declarations, as always, we've gone over this. It must avoid hearsay without exceptions. There are exceptions to the hearsay rule, but typically in these affidavits and declarations, you want to avoid that hearsay. No opinions, unless qualified expert. Again, that can be challenged. Based on current knowledge to the timeliness of those declarations or affidavits, and it's always going to be subject to cross-examination. Affidavits and declarations are sworn statements that carry the same weight as in-court testimony. So they can be cross-examined based on current knowledge and avoiding hearsay. Same as in-court testimony. And sworn or affirmed, I should probably say here, because it would carry the same weight. And we're on to Rule 56D. When facts are unavailable to the non-movement. Now that's the party that, so the movement is moving for summary judgment against the non-movement here. If a non-movement shows by affidavit or declaration that it cannot present facts essential to justify its opposition, the court may, there's a few things it may do, may defer or deny. The court may defer considering the motion or deny it entirely when essential facts cannot be presented. So interesting here is 56D. Allow more time. The court may grant additional time to obtain affidavits or declarations or to take discovery to gather essential facts. But this is may. Again, defer, deny. The court may. And other orders. The court may issue any other appropriate order to address the situation and ensure fairness in the proceedings, but they only may. So, the non-movement must demonstrate by affidavit or declaration the specific reasons why essential facts cannot be presented, and the court's response depends on the circumstances of the case. All right, and we're on to Rule 56E. Failing to properly support or address a fact. If a party fails to properly support an assertion of facts or fails to properly address another party's assertion as required by Rule 56C, the court may, and again 56C, affidavits, materials not cited, objection to evidence, and supporting factual positions. All right, let's get back here. So, if a party fails to properly support an assertion of facts or fails to properly address another party's assertion as required by Rule 56C, we just saw, the court may, opportunity to correct. Give the party an opportunity to properly support or address the fact. Consider it undisputed. Consider the fact undisputed for purposes of the motion. Grant summary judgment. Grant summary judgment if motion shows the movement is entitled to it, and other appropriate orders. Issue any other appropriate orders to address the failure. Failure to properly support or address a fact can have serious consequences, potentially resulting in summary judgment against the non-compliant party. So, very important to properly support or address a fact. Let's move along. And Rule 56, the final provisions. Section 56F, judgment independent of the motion. After notice and reasonable time to respond, the court may grant summary judgment for non-movement, grant on an unraised grounds, or consider it on its own. So that's judgment independent of the motion. 56G, failing to grant all requested relief. If a court doesn't grant all the relief requested, it may enter an order stating undisputed facts or treat the facts as established in the case. So those are judgment that are independent of the actual motion for summary judgment, at the discretion of the judge here. And Rule 56H, affidavit or declaration submitted in bad faith. There's the bad faith submissions. If satisfied that an affidavit or declaration is submitted in bad faith or solely for delay, the court may impose sanctions after notice and reasonable time to respond. There's financial sanctions. Order payment of reasonable expenses, including attorney's fees incurred as a result of the bad faith submission. Contempt. Offending party or attorney may be held in contempt of court. Other sanctions. Court may impose additional appropriate sanctions as deemed necessary. Bad faith submissions can result in serious financial and professional consequences for both attorneys and parties. Okay, so that concludes our little digression here onto Rule 56 of the Federal Rules of Civil Procedure. I hope you all are still with me, because now we move on to our presentation proper. All right, so as we saw here, Federal Rule 56 is designed for prompt disposition when no general issue exists. And we've just gone into crucially clear detail of how that works. All right, let's move along. All right, Section 1 generally continued here for the nature and scope. Although courts should be cautious about granting summary judgment in cases where motive, intent, or state of mind are at issue, they should be cautious. The salutary purposes of summary judgment, avoiding protracted, expensive, and harassing trials, apply no less to discrimination cases than to other areas of litigation. And these are recent cases here. I believe this is a 2008 supplement, so this is a little bit old. So even the supplement cases that we're referring to here are going to be the early parts of 2000. However, summary judgment is something that's been around for a good long time, and it's changing little by little like this. But at least you could kind of see where the changes really started to happen recently, and then you could find for further research the recent cases that are affecting any particular issue you might have around summary judgment. But let's proceed with these cases. The motion for summary judgment is designed to eliminate the delay and expense of litigating an issue when there is no real issue to be tried. And that comes from Connecticut, 2007. Also, we have this one here from the Florida Bar versus Green in 2006. Summary judgment is designed to test the sufficiency of the evidence, to determine if there is sufficient evidence at issue to justify a trial or formal hearing on the issues raised in the pleadings. Then that's a pretty good case there. Summary judgment is designed to test the sufficiency of the evidence, to determine if there is sufficient evidence at issue to justify a trial or a formal hearing on the issues raised in the pleadings. Then a motion for partial summary judgment is not a special remedy or a special application to the court, as is a special proceeding, but rather is merely one particular tool that may be used to resolve certain issues in the case, as we saw in the Federal Rule of Civil Procedure, the partial granting, right? And that comes from Keefe versus State Department of Motor Vehicles in Nebraska, 2001. And summary judgment rule is designed to eliminate the necessity of a formal trial where only questions of law involved and a fatal weakness in the claim of a party is exposed. That's Dalton versus Camp out of North Carolina 2001. And purpose of summary judgments is to eliminate patently unmeritorious claims and untenable defenses. That's from the Texas Department of Parks in 2004. All right. So now we're on to Section 2, as a drastic remedy.
Audit term says good info.
Yes, indeed. And I hope everyone's sticking around for this because, as always, we're going to have a little a special surprise at the end of this presentation here. So make sure you pay attention and then you'll be able to participate. Let's proceed. So Section 2 is a drastic remedy, the limits on use. Summary judgment is a drastic remedy. Yes, indeed, Bill Thomas. You got your hand up. Questions are always taken. Just pipe right in here in the chat. And I welcome everyone. If there is something else we need further clarification, we get the resources at hand. That said, let's continue on with Section 2. That a summary judgment is a drastic remedy that should be used with great caution, and only in cases where the justice of its application is clear. Because why? A summary judgment deprives party of a trial in the usual course. That's a drastic remedy. It must be used with great caution when justice of application is clear. It balances the rights of parties asserting claims and those opposing them. So it's a balance of those rights. It cannot become a substitute for open trial method of determining facts. So when there's truly disputed facts, it's not the proper remedy to resolve those. And it requires strict compliance with applicable rules. All right, now we're on to Section 3, statutory and rule provisions, the constitutionality. Statutes and rules providing for summary judgment under reasonable conditions and procedures have generally been held constitutional. A lot of presumptive language here, right? We have generally under reasonable conditions. Okay, statutes authorizing summary judgment upon failure to file affidavit of merits have been held valid. So, as we read before, those declarations and affidavits are evidence. Federal Rule of Civil Procedure 56 allows parties to move for summary judgment at specified times, as we saw. And when's the latest you could do it? No later than 30 days after the final discovery. Procedures identical to Rule 56 have been held not to infringe constitutional right to jury trial. So, if a state has rules, local rules, and they're identical to Rule 56, it's been held that they do not infringe constitutional right to jury trial. Interesting. External circumstances preventing defendant from defending does not make summary judgment unconstitutional. And due process is not violated when reasonable procedures are followed. Reasonable procedures. All right. So we're on Section 4 now, state and federal rules. State courts often look to federal court interpretations of summary judgment rules when state rules are virtually identical to the federal rules. So it's almost that you could use federal cases as what they would use for making their decisions rather than just influencing them. So state courts look to federal interpretations when rules are virtually identical. Federal court may modify state court summary judgment orders after removal. So if there's a summary, so if a summary judgment in a state court is issued but it's removed to federal court, they may modify a state court summary judgment. Interesting. And a rule that summary judgments is not granted if genuine issue exists is procedural. So that seems like something that is appealable. And procedural rules is not affected by state statutes in diversity cases. So when you have diversity jurisdictions, the procedural rules are not affected by the state statutes. So, state and federal rules we see here, the federal rules of civil procedure, not the rules of Texas rules of civil procedures, govern propriety of summary judgment in diversity case in federal court. So there's a good case there that shows it, and that's Brownsville Independent School District and the Royal Surplus Lines. Texas in 2005. All right, let's proceed. Section 5 is distinguished from judgment on the pleadings. Under the federal rules, both motions for judgment on the pleadings and summary judgment are available, but they are subject to different requirements. So motions for judgment on the pleadings and summary judgment are available under federal rules, but they are subject to different requirements. So judgment on the pleadings, only the pleadings are considered. With summary judgment, matters outside the pleadings may be presented, some of that evidence. Affidavits may be presented in summary judgment, but not in judgment on pleadings. Ooh. And different evidentiary standards apply to each motion type. So, for our practice guide here, if a court does not have subject matter jurisdiction to hear a case, then it cannot have jurisdiction to decide issues of fact and law to grant a motion for summary judgment, which acts as an adjudication on the merits. So it acts as an adjudication on the merits of summary judgment. Interesting. In such cases, a motion to dismiss for lack of jurisdiction over subject matter is the proper approach. So it would be a motion to dismiss for lack of jurisdiction over subject matter instead of a summary judgment. So you see that nice distinguishment there from a judgment on the pleadings and a summary judgment. The summary judgment would have that additional evidence, different evidentiary standards, and in some cases, the proper remedy. And we're on to Section 6, generally, the actions, matters, and proceedings in which authorized or available. The actions, matters, and proceedings in which summary judgments may be rendered are generally specified or at least governed by the authorizing statutes or rules. So statutes provide summary judgment authorization in contract, judgment, or statute actions. So the statute provides the authorization in statute actions, contract actions, and judgments. Construction of a statute presents a question of law appropriate for summary judgment. So wow, construction of statute. And originally designed for contract actions and expanded to all types of claims. Interesting there too, and fraud issues are not ordinarily proper subjects for summary judgment. So fraud issues are ordinarily not proper subjects for summary judgment. Probably based on all the facts that have to be, they're usually disputed facts in fraud. I would assume that's probably why that's the case. Nonetheless, all right, let's continue here. There are 3 classes of litigation not suited for summary disposition. Here are the 3 classes of litigations not suited for summary dispositions: negligence, states of mind, and equitable actions. So negligence, states of mind, and equitable actions. All those requiring adjudication of facts, it seems. All right, let's go on to some of the cases here from the generally of, what's the title here again? Actions, matters, and proceedings in which authorized or available. That's the heading from American jurisprudence verbatim. So, whether probable cause to arrest existed in a question is a question that must, let's read this again. Whether probable cause to arrest existed is a question that may be resolved as a matter of law on a motion for summary judgment, if there is no dispute with regard to the pertinent events and knowledge of the officer. So, whether probable cause to arrest exists is a question that may be resolved as a matter of law on a motion for summary judgment. So as we see here, the probable cause plays in the court, not usually at the scene. That's Weinstock versus Wilk. That's Connecticut 2003, adhered to on reconsideration 2004 in the District of Connecticut. Summary judgment is appropriate procedure for resolving challenge to federal agency's administrative decision when review is based upon administrative record, even though the district court does not employ standard of review for such motions set forth in the federal rule. So, again here, the summary judgment is appropriate procedure with the challenge with a federal agency's administrative decision when it's based upon the review is based upon the administrative record. So yeah, I guess there's no real dispute here, even though the district court does not employ a standard of review for such motions set forth in federal rule. But the federal rule would apply here. So there we go. That's why we went over 56 before this presentation, because you see here where there's a gap there, it's going to fill it in. So let's continue with some of these cases. Allegations of spoliation do not give rise to the independent clause of action under Texas law, and accordingly do not constitute claims subject to attack by way of a no evidence motion for summary judgment. So that's an interesting one there too. We talk about the spoliation, which is basically taking something illegally or by unethical means, but it's allegations of that do not give rise to the independent cause of action under Texas law. So an illegal taking, right? Allegations of that don't give rise to the cause of action, and accordingly do not constitute claims subject to attack by way of a no evidence motion for summary judgment. So that's an interesting one there too. Adobe Land Corp versus Griffin, and that's Texas Appellate, Fort Worth, 2007. The motion was granted December 4th, 2007. Rule 53F motion granted. All right, well, let's continue here. Issues of intent and knowledge are not susceptible of being readily converted and are generally inappropriate for summary judgment. So issues of intent, remember the state of mind, knowledge. So that's Four Brothers Boat Works versus Tesoro Petroleum Companies. And that's out of Texas. See, it was overruled and review denied, 2007. So there it is. Now we're on to actions on contract, Section 7. The interpretation of an unambiguous contract is a question of law. So unambiguous, no disputes, is a question of law to be determined by court and may be decided on summary judgment. So there's no disputed facts, then yes, interpretation of written contracts is particularly appropriate for summary judgment. Summary judgment may be granted only if agreement's language is unambiguous. Summary judgment is not appropriate if agreement is ambiguous, and issues of contractual intent, remember the intent, are particularly inappropriate for summary judgment. And questions of contract repudiation generally cannot be disposed of by summary judgment. So there are questions of that, that's their facts. So anything that's dealing with things like intent, state of mind, disputed facts, it's not for summary judgment. So, continuing with the actions on contracts, here's our practice guide. The course of dealings between parties to a contract for the purposes of interpreting an ambiguous contractual term is ordinarily a question of fact. However, if the evidence on the course of dealing is such that reasonable minds could draw but one conclusion, the question is one of law, and summary judgment may be appropriate. Generally, construction of a written contract is a question of law for the trial court, for which summary judgment is particularly appropriate. That comes from the Trust Court Mortgage versus Metro Mortgage in Indiana, 2007. And Section 8, negligent actions, summary judgment is not usually as feasible in negligence cases as in other kinds of litigation, because issues of negligence are ordinarily susceptible of summary adjudication, or not ordinarily susceptible of summary adjudication. Of course, because the defendant is entitled to summary judgment if plaintiff cannot recover as a matter of law. See, defendant entitled, so if there's basically no recovery for the plaintiff. Question of gross or wanton negligence, rarely disposed of on summary judgment. So we get to that gross, wanton negligence. Those are all facts that need to be adjudicated. Then we have summary judgment not appropriate if question of plaintiff's injuries exist. So again, it's a disputed fact. may be granted on liability, even if triable issue exists as to damages. So it may be summary judgment just based on the liability, and there's no reason to adjudicate based on issues of damages. There's the doctrine of assumption of risk cannot be applied in context of summary judgment. So here's our observation. What adds both to the intrinsic procedural difficulty of summary judgment and to some of the confusion in dealing with the device and negligence actions is that even if there is no dispute about how an accident occurred, the presence or absence of negligence often remains a question of fact, which requires a trial under traditional principles of the law of negligence. So good observation there. Let's move along and read some of the cases of negligence actions. Engineering and consulting firm for municipality had to explain why its evidence of its lack of awareness of rock at construction site was relevant, and why such evidence negated elements of contractors' claims that relied on existence of unforeseen rock at construction site. In order to obtain summary judgment against the contractor in contractor's lawsuit alleging negligence against the engineering consulting firms for a municipality that related to termination of construction contract by municipality under North Carolina law. What's that rock doing there? Okay, so lack of awareness. Explain why its evidence of its lack of awareness of rock was relevant. Okay, summary judgment is rarely appropriate in negligence cases because they are particularly fact-sensitive and are governed by a standard of the objective, reasonable person, one best applied by a jury after hearing all of the evidence. So that's from 2007. Let's move along here. And summary judgment should not be granted when issues are inherently for those of a jury, as in cases of intent, as we saw here. And that's, again, the four brothers and petroleum. Tesoro Petroleum. Issues of intent and knowledge are not susceptible of being readily controverted and are generally inappropriate for summary judgment. Same case with the four brothers. All right, we're on to Section 9, Equitable Actions, Specific Performance. Although equitable actions are not usually suited for summary dispositions, summary judgment is available if such actions in such actions if the general requirements are met. So it is available. Here's some general requirements. Summary judgment is appropriate in specific performance action if no genuine issue of material fact exists. The plaintiff is entitled to specific performance as a matter of law. Issue of plaintiff's laches or time expiring may be determined on motion for summary judgment. Nothing in Federal Rule of Civil Procedure 56 supports conclusion that summary judgment unavailable in former equitable suits. We saw there nothing about former. And courts may consider both legal and equitable factors in summary judgment analysis. So they can consider both the legal and equitable factors. May. All right. Come on. Let's see here. It should be changed any second there. It's taking so long. All right. Let's do it this way. Will probate, contest, or construction? The question of availability of summary judgment procedure and the propriety of granting summary judgment in will, probate, or contest proceedings has arisen in a number of cases. Oh boy. Some courts recognize procedure may be applicable in certain instances, but other courts have held procedure not available under certain circumstances. Availability depends on specific facts and jurisdictional considerations. So check your local jurisdiction. Court's discretion plays a significant role in determining applicability. So the court's discretion. And different jurisdictions take varying approaches to summary judgment in probate matters. All right. Let's move along here. Here's some cases. A genuine issue of material fact existed as to whether testator lacked testamentary capacity at the time she executed her last known will, precluding summary judgment in action brought by testator's family members to annul the will. Yeah, you got to work that state of mind one out, right? That's Louisiana, 2007. A genuine issue of material fact existed as to whether testator executed her last known will under the undue influence of her caregiver. Oh boy, precluding please give me everything. Precluding summary judgment in action brought by testator's family members.
494 says, this has really helped me understand summary judgment much more than I had. I needed this. Thank you very much.
Well, you're very welcome. Make sure we're almost to the end here, and we get a special treat here at the end. So you got to stick around to the end, and you'll be happy. Test your knowledge a little bit here. So as you see here, we have different cases here, whether the material facts exist. So state of mind and undue influence of her caregiver, precluding summary judgment. So because that state of mind, those material facts about capacity. So it's a material fact that needs to be disputed. It precludes the summary judgment. So these cases here need to go to trial, it seems. All right, now we're on to the affirmative defenses in the res judicata, section 11. A summary judgment may be properly based upon an affirmative defense, such as a valid release or res judicata, previous ruling on the case or on the matters. Valid release serves as basis for summary judgment. So if there is a valid release, then there is basis for summary judgment, no dispute in facts. Res judicata also, so previously decided issue may be raised by motion for summary judgment. Collateral estoppel may be invoked by summary judgment motion, and the court should not grant summary judgment if scope of earlier decision was unclear. So we have a good res judicata there. And defendant moving for summary judgment must establish all elements of defense. All elements of defense. As we saw before, the not too many rule kind of thing with demurs is similar here. Defendant moving for summary judgment must establish all elements of defense. I'm sorry, you don't want to do too many. You want to make sure every single one. If any of them fail, then the whole motion fails for summary judgment. So critical that all elements of defense are established. And section 11 continued here. We got some cases. Summary judgment is the appropriate method for resolving a claim of res judicata. So there's a previous ruling, yes, and that's from the Connecticut 2007. Summary judgment may be properly based upon an affirmative defense, such as a valid release. So this is in Ray's succession of Fisher, Louisiana Court of Appeals, First Circuit, 2007. All right, and it takes us to the quiz. Let's test your knowledge here. So, first question, and you can just put your answers into the chat with the question number and then pick your letter. And then we'll go over this. There's only a couple questions here, or 4 questions. So, what is the primary purpose of summary judgment? A, to determine whether there are triable issues of fact. B, to provide a forum for evidence presentation. C, to replace jury trials in all cases. Or D, to extend litigation timeframes. Okay, any takers there, just put them in the chat. We'll move on to question number 2. When is a motion for summary judgment considered a...
J 494 says, capital A. Bill Plymouth 4426 says 1-up.
All right, so we got 2 voting for the A. Let's continue here. Question number 2. When is a motion for summary judgment considered a drastic remedy? A, when it deprives a party of a trial. B, when filed by defendant. C, when filed before discovery is complete. Or D, when filed with affidavits. So when is it considered a drastic remedy, the motion for summary judgment? What's the drastic remedy? What makes it so drastic? Depriving a party of trial.
Jenk 494 says, capital C.
Okay, we got a C
Bill
there.
Plymouth 4426 says, capital C.
Is that for number 2? You sure about that? So I make sure, once again, the drastic remedy here we're trying to get at. When is it a drastic remedy? All right, we're going to move on to the next set of questions here. All right, number 3. What is required for a summary
Bill
judgment?
Plymouth 4426 says, I thought 30 days was required, so A.
Okay, yeah, that 30-day rules is one of the, it's a little bit of a trick there because that's thrown in from the federal rule. That means 30 days after the last part of discovery is complete. So after all discovery is complete, you get a period of 30 days. After that, then you're on to litigating facts, I believe. So, but that's under federal rule, and that could be changed by other courts. That's just like the if there's no other stipulation or order or anything against it, then that would stand otherwise. Okay, so let's get back to the quiz here. And we have here for number 3, what is required for a summary judgment affidavit? So now we're on to the affidavit. What would it contain? Personal knowledge of the affiant. B, expert testimony only. C, hearsay statements. Or D, opinions and conclusions. What's required for a summary judgment affidavit? Just think about affidavits and it should be easy enough. So that's question number 3. Is it personal knowledge of the affiant? A, expert testimony only for B, hearsay statements for C.
Jenk 494 says, capital A.
Okay, I would kind of say that too, because when we talk about affidavits, it's pretty straightforward. All right, so now we're on to question number 4. Which of the following is not a valid basis?
Bill Plymouth 4426 says, I agree A.
Yeah, that's an easy one there. We want to kind of keep this fun. So we're on to question number 4. Which of the following is not a valid basis for summary judgment? So which is not a valid basis? Let's say you had a valid release. A, res judicata. B, unresolved factual disputes. C, or collateral estoppel. D. So which is not a valid basis? So let's think of it this way here.
Bill Plymouth 4426 says, capital C.
All right, capital C. That sounds very sure. So we have unresolved, which is not a valid basis. So you're saying, all right, let's look.
Jenk 494 says, capital C.
Okay. So just to be clear, I love all these double, triple, quadruple negatives here. So which of the following is not a valid basis? Okay, so this is something that would not be a basis. So we have unresolved factual disputes. So that would mean that because there's unresolved factual disputes, there would be no basis for the summary judgment. Okay, if we had a valid release, would that be a basis for summary judgment, or res judicata, or a collateral estoppel? All right. Oh, before we go on, I went right past this one here on the first one, the fun fact. The first recorded use of summary judgment in American courts dates back to the 1850s. So, 1850s. We got a long history of summary judgment here in American courts. And we also had a fun fact here that the Federal Rules of Civil Procedure were first adopted in 1938, so sometime after that, and Rule 56 has been amended several times since. So that's an interesting read there to see all the amendments that have been done to that Rule 56. All right, now we're on to the answers. Let's see how he did. So, question 1, the answer was A, to determine whether there are triable issues of fact. The summary judgment's primary purpose is to determine if genuine issues of material fact exist, eliminating unnecessary trials. And question number 2 was also A. It's drastic. It's considered drastic when it deprives a party of a trial. It's considered drastic because it replaces a trial, a fundamental right in our legal system. So number 1 and number 2 were both A. And number 3, also A. Personal knowledge of the affiant. Rule 56, as we went over earlier, requires affidavits to be based on personal knowledge, not conclusions or hearsay or opinions. No affidavit should anyways, regardless of 56, but Rule 56 specifically requires affidavits in response or supporting summary judgment.
Bill Plymouth 4426 says 2 was tricky because illegal seems drastic.
Indeed, yeah, I had to put a trick question in there, but either way, it's good to test your knowledge this way. All right, we're on to number 4, and unresolved factual disputes. Summary judgment requires, C is the answer for number 4. Summary judgment requires no genuine issues of material fact. Unresolved disputes create triable issues. And I think we all easily get that one. That was an easy one as well. So yes, another fun fact here. The term summary judgment.
494 says, Bill is the quiz A, Bill.
Yes, indeed. Everyone did well, and the participation is key here. And again, if you're not happy with your answer, you can always just go and delete the comment. That was just our little test your knowledge there to have a little bit of fun, to make sure you leave with some takeaways from this and make you think deeper.
Bill Plymouth 4426 says you as well. Nice work.
Yes, thank you. And indeed. So we have one last fun fact here to go over. And our fun fact is the term summary judgment was first used in English courts in the 19th century. So not long before it was used in American courts, it began over there and in the English courts. So with that said, I'd like to thank you all for attending this session here of summary judgment. We do have other parts to go on with this so we can complete the American Jurisprudence volume on summary judgment. I think these kinds of concepts are very important because trial.
Birthday official says, great presentation.
Well, thank you, and I'm very flattered to have you all here and attend it. And the participation is what really makes it fun here too at the end.
Jenk 494 says, thanks, Bill. This was fun.
Yes, indeed.
Bill Plymouth 4426 says, nice learning with you all.
Indeed. We have a whole nother one coming up with summary judgment, and I have it already formatted in the similar fashion here. So we'll have some more fun with this, and I think by the end of it, we'll have probably a better understanding of the foundation of summary judgment than a good 99% of the population. But summary judgments affect a lot of us. It probably affects close to 80% of the population, knowingly or not. So by having an understanding of this and the way our legal system does function and affects us all, it's a way of empowering us to be better informed, more aware, and able to act to better protect our rights. That said, thank you all for attending, and I hope to see you all on the next one. Peace out.
Bill Plymouth 4426 says, my favorite terms in this one were spoliation and estoppel.